Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. Today I have the pleasure of speaking with Patricia Savitz from the Florida Bar. She's in the Orlando office for the Bar Grievances. Patty, welcome. Thank you for joining us.
Thank you for having me today.
Absolutely. First of all, can you tell us what is the process when a bar complaint comes in against an attorney? What happens?
Well, it originally goes to our Tallahassee office. They go through them with an intake process and close a large number of them. Anything that needs further investigation is sent to the branch offices, and we have 5: Orlando, Tampa, Tallahassee, Miami, and Fort Lauderdale, and then it's assigned to a bar counsel such as myself. We do further investigation. We close a number of those cases as well. The ones that cannot be closed and need further review go on to the grievance committee, which functions like a grand jury. It's a review panel made up of 9 members, 6 attorneys, 3 non-attorneys, and they take the investigation from there. And they also have the ability to close the cases, as do we as the staff attorneys. In some occasions, they use diversionary processes, which means there may have been something that went a little wrong, and they divert the attorney, which means once the attorney completes the diversion process, the case is closed without any type of finding. In some cases, they do have to find probable cause, which authorizes the bar to file formal charges against that particular lawyer with the Supreme Court of Florida. And then from there, it proceeds like a bench trial. It's an administrative proceeding before a sitting circuit judge or a county court judge. And everything is reviewed by the Florida Bar Board of Governors as well as the Supreme Court. And discipline is based on case law that comes before it. But prior to that, there are lots of opportunities for investigation, for information. We meet with the attorney, we meet with the complainant, either by phone or in person, and gather information to determine, is there really an ethical violation here? Is there really an issue?
So let's back up. When the bar complaint comes in and say it's not done away with at the intake level, I guess, say it's gone to the grievance committee, that will be assigned out to an investigator, and then the person that has received the grievance, they are given an opportunity to speak?
Yes, what happens is our investigating member, and sometimes they work in tandem, there might be 2 members, speak with both the complaining party and the respondent attorney to get more information. Oftentimes, it's a complete picture of what happened. The complaint says one part of the story, the response from the attorney says the other part of the story, and the investigating member is able to put the pieces together and look at the nuances. What is the undercurrent here? What really took place? Is somebody dissatisfied, or maybe this wasn't the lawyer on his or her best day? The critical piece to all of this, though, is getting that written response from the lawyer. And the Supreme Court has said we are all required to respond in writing to these bar complaints, whether we want to or not, whether we like the complainant, whether the complainant was our client, whether we believe what he or she said, we still have to respond. And I like to always tell people, please never, ever, ever send the bar, whether it's our intake office, whether it's the local bar council or the grievance committee, never send them your first response. Please make sure somebody takes a look at it. But with that communication, it's built upon as far as the investigation goes. So it's not a hearing when the attorney and the complaining party meet with the members of the grievance committee, but it's just a meeting to get more information to determine really what happened here.
Okay. And then say you mentioned diversion. Can you talk about that a little bit? Essentially, there's not going to be a finding of probable cause. They're going to divert that attorney. How long is that kept on record as far as the attorney talk about if there has been findings of probable cause against them and then disciplinary action? Can you talk about how long is that on your record, so to speak?
Well, the first thing is only public disciplines are going to post to the bar's website the section that says find a lawyer. So a diversion, if it's a grievance committee level, will not post there because that's not a public form of discipline. Closure by a staff attorney, closure by the committee won't post there. There'll still be on closures a 12-month record of that, but at the end of 12 months, the electronic data disappears. Okay. So if you have a situation where you might do criminal work and your former client a couple years from now might file another complaint again, you need to really save that paperwork because the footprint disappears. On a diversion case, once the attorney completes whatever he or she's been diverted to do, some form of professional enhancement, it could be CLE classes, it could be a course, anything like that. After 12 months from the closure of that case with a diversion, as long as the diversion's been completed, that footprint goes away as well. When the grievance committee finds probable cause, the case becomes public, and when the Supreme Court issues an order of discipline, that becomes public, and that's what posts up to the webpage.
All right, and final question, as far as the different types of discipline, can you run the gamut of what all that entails?
Certainly. We first start with the dismissal, and that's what we look for. What are the facts of the case? What tools can you give us for the case to be closed? After that, we have diversion, which means something may have happened, but we can improve upon the attorney's practice. The next would be a minor misconduct, which is usually an admonishment administered in writing or before a grievance panel. That's a permanent form of discipline, but it's the smallest form of discipline. From there, with probable cause, again, we go admonishment, public reprimand, short suspension, which means on the very next day you're eligible to practice, and then something we call a rehabilitative suspension. But what that means is once that suspension is over, then you begin the long process of trying to become reinstated to practice. And then, of course, disbarment. The one thing I would let everybody know is that nearly 70% of all cases are closed without a finding, either by a staff attorney like myself or a grievance panel. The balance of those cases resulted, last year's statistics show 350 public disciplines in that find a lawyer section. So the good news is nearly all of us are doing excellent work.
That is fantastic news. Patty, thank you so much for being here today. You've certainly informed us very greatly on the whole bar grievance process and the different sanctions that are available. Hopefully none of you end up needing that, but if the case may be, then it is what ends up happening. Certainly check back with the Mentoring with the Masters video series for all types of videos, not only dealing with bar grievance process and procedures, but for all aspects of your practice. Thank you again for being here.
Thank you.